I guess both sides have agreed that we can go forward with the Wallace case a little early.
Thank you for taking us early.
Oh, that's fine. You have 15 minutes and you may reserve up to 5.
I would like to reserve, I think, 3.
That's fine.
Thank you. Good morning, judges. I'm Leslie Gentili. I represent the husband in this case, Ronald Wallace, the appellant. This is a divorce case. The parties were married for just a very brief period of time. They were married in November of 2009. By January of 2011, the marriage was virtually over by everyone's agreement and testimony. And frankly, even during that period of time, they didn't really live together ever. It was a fairly unusual situation. In January 4th of 2011, there was a criminal incident that occurred when husband encountered his wife in bed with another man. As a result of that, husband was convicted of a felony, and in his mind, the marriage was over. The wife had also indicated the marriage was over, and she filed for divorce. There was testimony also that indicated she believed that by July 2010, the marriage was over. So this was, by any assessment, not a very successful or traditional marriage. Wife filed for divorce twice. There was no counterclaim filed, so when wife dismissed her divorce on each of those 2 occasions, the case was over. The third time was the charm. Husband did file a counterclaim, and that case ended in a contested trial, which brings us here today. The parties were divorced as a result of that in November 2014. Yes. There was no stipulations or agreements by the party whatsoever. The matter went fully to trial. There was no agreement at any point during that trial. We are here today because there are several errors that were made by the trial court that we believe should cause this case to be reversed. The wife's 401k was not considered by the trial court, even though evidence was presented by the wife of that 401k.
And that was the pay stub?
Yes, ma'am. I believe it was Exhibit 6. But that was the pay stub that clearly sets forth that there was a 401k and that there's a monthly contribution being deducted from wife's pay to contribute to that. The court also failed to consider and allocate and characterize as separate or marital property a parcel of land that husband had in the state of Indiana, real property. So in Bisker versus Bisker, Ohio Supreme Court case requires that every asset be discussed and characterized and allocated by the court. To fail to do so is reversible error. That position is also articulated in Vanderpool case out of this district in 1997.
Is it reversible error or is it even non-final?
It could be that as well.
Because you haven't really...
Exactly. There are 60B issues then implicated, and yes, that's correct, Your Honor. That's a Bisker premise. The second error that the trial court made, in our opinion, is that the division of marital property was not supported by competent, credible evidence. In that the marital debt and the discussion of the parties, when they got married, shortly after they got married, within 5 months, took out a $50,000 home equity loan against wife's premarital home, which was encumbered also by a first mortgage. So this was a $50,000 second mortgage that was signed or obligated to only the husband, since wife couldn't get the credit. So the wife's house was the collateral, but the obligation of the debt, according to the lender, was the husband. There was some discussion about what those funds were used for. There was about $23,000 that the husband took from that to pay his premarital debt. The wife got $10,000 by her own testimony to pay some premarital debt of hers, plus another $2,200 for a car for her son, I believe, and a mortgage payment on her first mortgage. So wife had some, husband had some. The trial court doesn't didn't address the fact that wife took $10,000 to pay her premarital debt. For some reason, that was left out of the court's analysis. There were just many errors in the application of the facts, and frankly, in math. There was just computation errors and errors of analysis by the trial court. The trial court also made in its findings that the house ultimately sold after about 2 years after this equity loan was taken out. The house sold for $155,000. A settlement statement, a HUD statement was presented to that effect at trial. Court's findings say house sold for $151,000. So that was an error. The court also found in its findings that the home equity balance at the time of sale was $39,946. In fact, it was $50,000. The full amount was still outstanding. The court, when the house was sold, there was a shortfall of $10,000. The first mortgage was satisfied. The home equity line was satisfied to the point of $40,000 and some change. Husband then became solely liable for that $10,000 thereafter. The court gives him no credit for that and doesn't explain why in its findings. And finally, at the point at which the marriage was entered into, there was an $87,000 mortgage on wife's first mortgage on the house. By the time the house was sold, 2 years after the home equity line was taken out, the mortgage had risen to $102,000 and some change because wife failed to make payments. She failed to make any payments at all, though, so there was interest and penalties additionally assessed. So there was about a $15,000 windfall that wife received, the difference between $102,000 and $87,000, because the court didn't discuss that or allocate that in any way. Due to wife's own failure to pay her own mortgage, $15,000 additionally was added to the mortgage balance at the time of sale. That was subsumed by the equity in the house, and the trial court did not address or allocate that, which in our position is a windfall to wife. She should have paid the mortgage, and had she done so, another $15,000 would have been available at time of sale. The most troubling aspect of the trial court's decision is the fact that the court found some kind of an agreement between the parties. The last several pages of the court's judgment entry articulates that the parties agreed to certain things and that it is the parties' intent, most notably that there be a bankruptcy, a prohibition on bankruptcy should a party default in the payment of an obligation. The only one that had an obligation pursuant to the trial court was the husband. He was ordered to pay wife $28,000. The court found that it was their intent that if he files bankruptcy, that the wife or the injured party come back to court and get a spousal support order in that same amount. In other words, effectively limiting his federally sanctioned opportunity to file bankruptcy to relieve himself of debt. The court found that they had agreed to that and that that was their intention, when there was never an agreement, there was never a discussion of that in the trial. There was never any agreement of any type and kind. The court also found several other kinds of agreements. Again, there was no agreement at all. Where the court discovered these alleged agreements from is not discernible from the record.
There was no testimony about the parties' intent when they took out these obligations?
There was testimony, yes. It was when they took out the $50,000 home equity line, they had both intended to pay premarital debt. It was within 6 months of their marriage. And they both did that. Husband about $23,000, wife about $10,000. That testimony is uncontroverted. Beyond that, there was no other intention about anything. And certainly there was never an intention at the time of trial that husband be precluded from filing bankruptcy. And that was just never discussed. And there was certainly not an agreement about that. Although the court's order and findings indicate clearly that there was an agreement. And frankly, I don't believe it's within the court's authority to order of its own accord that a party can't seek a bankruptcy remedy. I know that the parties can agree to that and often do, but the court does not have the authority, I don't believe, to order a prohibition against bankruptcy as a remedy. And for these reasons, Your Honors, we believe that the court certainly lost its way. It abused its discretion. It made clear errors, both in its factual assessment and in law. And for those reasons, this matter should be reversed. Thank you.
May I approach?
Sure.
Good morning, Your Honors.
Good morning.
My name's John Haynes. I'm in my 48th year of practice in law in this court. This case is in my top 10 greatest hits cases for the facts. Karen Wallace was divorced. She received a house out of that divorce settlement. She met Ronald Wallace, dated him for a few years. They got engaged. Shortly before their wedding, he talked her into taking out a $50,000 loan on her house. The loan went to him, all $50,000. And he paid off his debts, $12,000 worth of her debts. So he received and controlled $38,000 of that $50,000 loan. And then, shortly after receiving the money and paying off his debts, he took off and went back to live in Vermilion in a home that his parents owned. And from time to time, in the next 5 years, he would wander back to the arms of Karen Wallace, stay a while, and then leave. He was back for a rather longer time than usual when he broke into a friend of Karen Wallace's house, committed serious felonious assault upon that man, and was indicted by the Lorain County Grand Jury. And in order to save his job and get probation from the judge, he came wandering back to his wife. There was no evidence that she was in bed with this other man. He was a friend. And throughout this entire case, the lawyer for Ronald Wallace did no discovery, did not file a settlement conference statement. He didn't file a proposed judgment entry and findings of fact that were requested by the court at the close of the evidence in the trial. I did. In fact, I gave the court my proposed entry just prior to beginning testimony in the trial, which the courts require in Lorain County. We did not ask for the property in Indiana. We made no claim to that.
Matter?
I'm sorry?
Why does that matter, sir?
Because counsel is claiming that's reversible error.
Well, but that's my whole point.
It was premarital, Your Honor. It was totally his before the marriage.
Yes, I understand that, but it was still property that he owned during the marriage, right?
We made no claim for it.
Well, does that matter? That's my question.
Yes, it does.
Does that matter? Why, but where's the case law that says that matters, sir? Because I thought the case law provided that every piece of property has to be allocated and determined whether it's marital or not marital. I thought that was what the rules were.
I don't think it's reversible error if it's not requested. There was no evidence brought in about that piece of property where we were making a claim. I think the situation in this case is that under Blakemore versus Blakemore and numerous cases that have been cited in my brief from this Court of Appeals, the issue in this case is simply, did Judge Boros, did she act in a capricious, arbitrary, unreasonable fashion when she allocated the award that she did to my client? Because I presented a proposed judgment entry, and I was the only one that did it in this case, my judgment entry was a standard entry that I do in all of my cases, and the last 7 or 8 paragraphs, or the last 2 or 3 pages that the defense appellee is talking about, I think Judge Boros simply adopted that language.
But isn't that problematic? I mean,
it doesn't have anything to do with the award here. None. This man had come in and out of her life after they got married. He worked at the Norfolk and Southern Railroad. He had a pension. That came out in evidence. And the judge properly felt that she was entitled to one half of the marital portion of that pension.
What about the 401K?
The 401K was mentioned in my settlement conference statement, and there was nothing else, no evidence presented. His lawyer made no effort to find out the value of it.
But I think, again, doesn't the case law provide the court has to do that?
There was never any mention of it in the trial. I mean, there was no mention, no request for a portion of it.
Well, in your affidavit, your financial disclosure affidavit that's filed when you file your divorce thing, or when you file your answer and counterclaim, you have to file a financial affidavit, and you have to fully and completely disclose, and it's an affidavit that's a sworn statement. It isn't value something that's required to be provided on that form?
I don't know whether that was filed in this case. I'm not sure that there was such an affidavit filed. All my client wanted was the money that she had lost, $28,000 and some dollars, that was awarded to her. She wasn't asking for spousal support. And obviously, if this court has the right to take certain portions of the judgment entry of the court and make changes to it, that's fine with us. But my client is the victim in this case.
Well,
Absolutely. I mean,
that may or may not be. The point is, though, we have to look at what the law requires for a trial court to do in a domestic relations case.
And the test here is whether it was unreasonable, arbitrary, and capricious on the part of the lower court. And if you look at all the facts.
But when you say if you didn't address it, it's unreasonable, if you didn't even address it, and it was definitely an asset of one of the parties, you never even addressed it.
She can't address it if there's no evidence presented about it. That's the problem.
But don't you have to file an affidavit, a financial affidavit that states what you own?
I did that in the settlement conference statement.
What
And they didn't
value of it
file it.
was.
No settlement conference statement was filed on behalf of the defendant, of the plaintiff in this case. And he's the plaintiff. No discovery was taken. I mean, if we were to retry this case, then what you're suggesting is that we go out and spend $450 and have a piece of property that we make no claim to in Indiana that was premarital in nature appraised, and we're going to spend another $400 to $500 on appraising pensions.
Why would you have to have the property appraised when all you have to do is establish the date that he purchased it, and what he paid for it, what's the still owe on it? I mean, that's not appraisal, that's just, here's what I bought it for, it's only in my name, it was purchased before the marriage, and here the marriage is over, and...
That's the same as saying there's no claim for it.
But you have to say it, don't you?
I never made a claim for it in my settlement, in my statement.
The court has to say it.
Perhaps. Now, you can correct that. You don't have to change the award here to correct that. You're
Correct,
allowed to do that.
that's true, but the trial court doesn't even say it. Even though it doesn't change anything, the trial court doesn't have to fully
Okay.
and completely...
So why don't you order the trial court to say it and be done with it? You're allowed to do that under the law. The law allows this court to make certain changes that they feel would be reasonable in the judgment entry. In that case, you're allowed to award alimony. And there's plenty of evidence to show what this man was earning and what she was earning. That would be fine by us. So I rest. Thank you.
Thank you.
Your Honors, I believe the test in Bisker, the Supreme Court case, is controlling here, and it's clear. Every piece of property must be identified and allocated, and characterized as marital or separate, allocated. However, the fact that it's de minimis value, or there was no claim, or whatever wife is arguing, is irrelevant to that obligation that the Supreme Court has set out. for the trial court. The wife has referenced no discovery, no settlement conference, no proposed judgment entry. These are things that were not in the record and are irrelevant as we stand here today.
Well, wait a minute, I'm confused. I think the wife is saying, the counsel is saying, one was never filed on
Correct.
behalf of the appellant.
Correct.
In the trial court below. And I think that the argument is, if this was not discussed in the trial court, it cannot be assigned as error on appeal because there would be nothing for the trial court to have.
He's saying, or wife is saying, that no settlement conference statement was filed throughout the case management process of that lower court, of the trial court case. That's true, by husband. However, that was not, the testimony in the trial, that was not part of the trial record. What did happen at trial is wife's pay stub was presented and admitted as evidence, as an exhibit. And on that pay stub, it clearly states that wife has a 401k. And frankly, by counsel's own admission, he indicated that she had a 401k on his settlement conference statement, which he did file.
Then may I ask, why was there no subpoena for just taking sent to the party that had the 401k?
I can't speak to that, Your Honor. I was not the lawyer at the lower court level.
The information was available, but nobody pursued it.
If the 401k is going to be divided, it's not necessary to know the value of it. You can just indicate that the 401k is divided from the date of the marriage to the date of the final hearing, and the plan actually does that computation.
Depends on where you are, Portage County requires it.
Really? Okay. They don't require
But your
your...
financial affidavit is a standard form the Supreme Court provides, and there is a line that says value on it, so at some point in time, you know what the value is if it's a 401k.
Right.
And it's a sworn statement, so you didn't put the information, or somebody didn't put the information on there. I mean,
It's certainly at the trial level, the information was made available to the judge, to the trial judge, through the wife's own exhibit. It's not husband's duty to elicit that information. The wife provided it on her pay stub. There clearly was a 401k that was not addressed or accounted for. That's not a dispute, just like the Indiana property. I believe that Visker requires that those are both reversible errors. And frankly, we don't agree that the wife's entitled to $28,000. There are enough math errors here. I think I discussed 5 or 6 of them. The whole thing needs to be recalculated at the very least. I think the math is convoluted and frankly just not correct. The subtraction was incorrect. So for that reason, in addition to the others, the case needs to be reversed and potentially remanded, and let's figure out really what these numbers are supposed to be. And frankly, husband lost his job as a result of that felony. He lost his pension with Norfolk and Southern. He did get rehired in a much lesser position as a laborer, no longer a supervisor, and makes substantially less and just started a new pension that has very little value. But we did argue the de facto termination because the fact that the parties just never really lived together, and frankly, after that incident in January of 2011, they just never lived together again. So there is testimony in the record that supports those conclusions, and it's our position the marriage should have been ended at the latest as of January 4th, 2011.
Yeah, about 30 seconds.
Thank you.
Thank you. The court will take the matter under advisement, and a written opinion will issue and be sent to both of you as well as released on the Supreme Court website and our website. Thank you, Your Honor.